The idea of a responsive state, as introduced by Feynman, calls for a state structure that will improve society. Aspects of that structure and its legal system that should be amended in the quest for social improvement will be discussed in this presentation.
When defining the term responsive to universal human need, it could be interpreted as the need to address the universal vulnerability. This was introduced by Feynman and was further reinforced by Birkenbach, together illustrating that resolving universal vulnerability can be seen as being responsive to universal human need. In addition to this, state action significance was also emphasized, as evident from Feynman and Nussbaum. Though there have been critiques over the disadvantages over too much state interference, they fail to acknowledge state interference's inevitability as suggested by Claude. Hence, a responsive state through governmental institutions and lawmaking needs to foster resilience, and two of the essential areas are in regard to legal capacity and mental impairment. Legal capacity's most significant legislation involves UNCRPD Article 12, where legal capacity is considered as a universal human right and offers supported decision-making as defined by series. This initiative requires fundamental changes and needs to be achieved through state power, as evident in the CRPD Committee's comment along with Owen and Griffiths' quote, indicating the necessity for a responsive state in fostering resilience amongst its citizens. An example of this could be the UK having ratified the UNCRPD in June 2009, taking more initiatives in solving issues relating to universal human needs, as evident in the case of AH versus West London MHT. Another essential area is mental impairment and the Mental Capacity Act of 2005, where it established a legal framework for decision-making on behalf of another individual if they're found to lack mental capacity, even though it had been heavily criticized as per Sir Brian Levinson. It remains a valid attempt in which the state had tried to actively engage with the universal human needs. In conclusion, the section highlights the responsibility and significance of a responsive state.
A responsive state should be able to respond to vulnerability. Many reforms and approaches have been suggested, but three are the leading candidates: the abolition with support, the mental capacity with support, and the support except where there is harm model. The abolition with support model requires the complete repeal and restructuring of the mental health law. It removes all required legal compulsion for hospital admissions or psychiatric treatment. This model would instead offer direct and indirect help. The support given would likely vary from case to case, helping the individual better understand their situation and asserting their will and preferences. The issue is that while it gives people with mental impairment more autonomy and resilience, it also creates a new vulnerability for them. For instance, if the individual's mental impairment causes them to commit a criminal offense, there will be no laws to prevent the criminal justice system from engaging. The mental capacity with support would involve essentially changing the criteria by which involuntary detention and psychiatric treatment is given out. This would change from assessing the risk of harm of the individual to themselves and others to a medical assessment of their mental capacity. This would allow people with mental impairment who have been assessed to have mental capacity to make their own legally binding decisions. Through this model, people lacking legal capacity after receiving support can be recognized by the law as having mental capacity and being able to take legally binding decisions about their treatment. The problem is mental capacity assessment is highly subjective, and people who are deemed as not having mental capacity will still be vulnerable and restricted by involuntary treatments. New stereotypes could surface where people contradict their doctor's suggestions, as a result being deemed as not having mental capacity. The support except where there is harm model prioritizes support and choice. However, it will allow limited involuntary detention and treatments where there is risk of harm. Unlike the previous two models, this one does not move away from involuntary treatment and detention, but it gives the individual the choice when such restrictions are necessary. For instance, it abolishes the nearest relative rule and allows the individual to choose a representative of their own. The main issue is that there is no accurate way to determine when someone could be at risk of a harm or will put others in risk of harm. This will result overestimation of risk assessment and will result in people being restricted when there could very well be no actual risk of harm.
The idea that existing legal structures are centered in a system of individual liberty, ignoring the realities of human dependency and vulnerability, is true to a large extent. The current legal framework reflects liberal legal values. Though liberal legalism has proven effective in providing stability in the legal system, by promoting a fiction of autonomy, it fails to recognize societies differently vulnerable. Vulnerability theory challenges the ideas of liberal legalism. Feynman's approach suggests it's not specific groups who are vulnerable, but rather that society as a whole, and that each member of society will experience different vulnerabilities depending on the resources available to them. The quote on the slide promotes the idea of an overarching human equality within society. Scully suggests those who are disabled and have embodied vulnerability are no less vulnerable than others who don't possess a disability, but are rather vulnerable in different ways.
Feynman suggests that autonomy is a myth. People need or will need some type of care in their lives. No one would make it to adulthood without the support of members of society. This is true in their decision making when discussing legal capacity. People tend to emphasize capacity, independence, or autonomy in their decision making. This is because of universality of our vulnerability means that we need to challenge the myth of our independence and reconsider the society, in particular, the state's response to such decisions. As shown here, it is highlighted how the CRPD demands that the state should provide support for legal capacity. If we were to question the liberal legal subject, it then becomes more difficult to suggest that the response of the state or society should be non-interference. This has been interpreted as providing legal structures which should recognize rational decision-making. It is also interpreted that to facilitate real choice requires a recognition of wider environmental challenges.
By recognizing individuals' inherent embeddedness within society, we can understand the significance of social relationships in both social and legal structures. Relationality is a concept that recognizes the links between individuals within society. The support needed by individuals to make decisions is a universal need, rather than something required by those with mental impairments. This quote put forth by Mackenzie reiterates that support is required in cases of both physical and mental impairments, and that social connectedness is vital for the survival of society, as the disruption of persistent relations can negatively impact the core capabilities of individuals.
The Mental Capacity Act, MCA, follows the ideal of autonomy from a legal perspective. It requires from people that their decision-making is to be done alone and with no help at all, and therefore the atomized individual of the liberal legal subject. It is an abstract standard of autonomy. It states that the liberal, self-sufficient, rational man is capable of their own decision, making without the interference of anyone. It doesn't acknowledge any of the external and social factors which heavily influence decision making. Instead, it chooses to consider only the internal influence of the mental impairment. This then heavily relates back to the idea of human embeddedness. Overall, vulnerability theory has been used to explore the appropriate components of a responsive state. By addressing the issue of vulnerability as the universal human need, it is shown that the role of a responsive state is essential, as evident in the necessity of state-imposed measures as a means to foster resilience and to combat against vulnerability. Varying structures were put forth in an attempt to assess the reorganization of structures, but each one fails to fully address vulnerability, with some arguably having major flaws. Despite the wish for a more responsive state, it is hard to implement a fully functioning structure. In our analysis of legal liberalism, it can be seen that vulnerability theory does much to challenge the idea of a legal liberal. When reviewing the concept with regards to the myth of autonomy in the MCA, it can be concluded that the myth of autonomy provides legal structures which reorganize rational decision-making. It is also evident that to facilitate real choice requires a recognition of a wider environmental challenges. We can also see how the MCA follows the ideal of autonomy from a legal perspective without consideration for any other external or social influence on the liberal legal person. Though the idea of a responsive state remains in an attractive ideal, real-life obstacles make it difficult to be fully implemented to address the society as a whole.